Well, welcome to AEI and today's event, McCulloch versus Maryland, or v. Maryland at 200. I'm Gary Schmidt. I'm a resident scholar here at the American Enterprise Institute, and I'm executive director of the program on American citizenship. I'm pleased to be joined here with 5 friends and 5 distinguished scholars, Christopher Wolfe from the University of Dallas, Michael Zuckert from University of Notre Dame, Robert Webking from the University of Texas at El Paso, Abram Shulsky from the Hudson Institute, and Adam White, the Hoover Institution, and George Mason Law School. We'll be discussing McCulloch v. Maryland. We'll be discussing Marshall's opinion, his defense of that opinion, the place of the bank in U.S. fiscal history, and Marshall's statecraft. For the biographies of the panelists, there's a handout so you can take a look at their accomplishments with more depth than I'm going to do here. Or if you're watching this online, if you go to the AEI website for this event, you'll also find the biographies. I'll just really say very shortly, I'm really pleased they all could join us today. It's a great lineup. Our format's going to be pretty simple. Each of the panelists will speak for about 8 to 10 minutes. After that, we'll open it up for discussion among the panel to dive more deeply into the issues surrounding the case and its impact historically. Then we'll have time to take questions from those of you who've joined us today. Following that, please feel free to join us for a reception, which will include beverages, as the Constitution might say, both necessary and proper. Now, turning to the topic at hand. Chief Justice Marshall's opinion, issued on March 6, 1819, was arguably one of the 2 most significant opinions among the hundreds he wrote, the other being, of course, Marbury v. Madison. For many historians, legal historians in particular, Marshall's opinion in McCulloch is the greatest in its legacy on both how the Constitution is read and for understanding the relative powers of the federal government and the states. And indeed, sentences from the opinion, such as, "We must never forget it is a Constitution we are expounding," end quote, "the power to tax involves the power to destroy," are repeated endlessly in the country's law school classrooms. So while the opinion is a matter of history 200 years ago, it is a history that has relevance for how we understand and debate the constitutional order to this day. Marshall himself, of course, is remembered as the first and arguably the greatest Chief Justice, although that is the most important role he played as a founding father. It's useful to remind ourselves that while Marshall was related to the landed gentry of Virginia, he grew up in a log cabin, shared it with 14 siblings on the frontiers of Virginia. He had only 1 year of grammar schooling and only six weeks of law school. Maybe that was an advantage, actually. I never thought about that. Marshall gained prominence as a military officer during the Revolutionary War, was a successful attorney, was elected to the state assembly on numerous occasions, was a key member of the ratification convention in Virginia, was a diplomat and something of a national hero arising out of the XYZ affair with France, was a member of Congress, served as Secretary of State, authored a biography of George Washington, and finally served as Chief Justice from 1801 to 1835. In short, Marshall was an individual deeply experienced not only in the law, but politics and statecraft as well. Now, turning briefly to the case itself, Congress had chartered the First National Bank in 1791, but that charter had expired in 1811. Because of a fiscal crisis in 1814, James Madison had urged Congress to establish a second bank, which it eventually did in 1816. The federal government, held 20% of the shares, while private investors, including foreigners, held the rest. 18 branches were then established throughout the country, including in Baltimore, Maryland. The state government there imposed a stamp tax on the banknotes issued by the National Bank. The manager of the Baltimore branch, James McCulloch, refused to pay the tax and was convicted in the state court for violating the law. The decision was then appealed to the Supreme Court, the U.S. Supreme Court, in which two key issues were addressed. 1, did Congress have the constitutional authority to charter a bank? And 2, did a state have the power to tax it? Marshall's opinion affirming Congress's authority to charter a bank and striking down Maryland's tax was immediately attacked privately and publicly by the likes of Thomas Jefferson and other leading Republicans as a perverse reading of the Constitution, suggesting that the common depiction of this period as the era of good feelings might be overstated. So with all that as preface, I will now turn things over to the panel, starting with my guest, Chris Wolf.
In an effort to keep to my time limits, I'm going to speak on only one part of a paper I've written. I want to focus my remarks on a paragraph from the second part of Marshall's opinion in McCulloch. It's this paragraph. If we measure the power of taxation residing in a state by the extent of sovereignty which the people of a single state possess and can confer on its government, we have an intelligible standard applicable to every case to which the power may be applied. Later in the paragraph, we are relieved as we ought to be from clashing sovereignty, from interfering powers, from a repugnancy between a right in one government to pull down what there is an acknowledged right in another, to destroy what there is a right in another to preserve. We are not driven to the perplexing inquiry, so unfit for the judicial department, what degree of taxation is the legitimate use, and what degree may amount to the abuse of the power. I think what Marshall says here helps to explain some of the deep differences between traditional pre-1890 and modern post-1937 judicial review. Why is the degree of taxation that is legitimate or an abuse and a perplexing inquiry that is so unfit for the judicial department? Why would Marshall even raise this question? One possible argument in defense of state taxes on federal instrumentalities might have been that surely relatively minor taxes that did not obstruct the operation of the federal instrumentalities were not constitutionally objectionable. Only if the taxing power were abused by imposing a tax that obstructed federal action would a problem arise. This argument could be taken in several directions. Maryland could have said, as it did in McCulloch, that the Constitution simply had confidence that the states would not abuse their powers. Marshall, of course, lavished some pretty heavy sarcasm on that contention. Alternatively, it might have been argued that the judges could strike down taxes that were an abuse of the taxing power, leaving intact those that were not. But Marshall thinks that question about the degree of the taxing that was legitimate or an abuse is not fit for judges. Why? I think Marshall said this because judges, in making decisions about such questions of degree, would receive no guidance from the law, from the Constitution. What would guide the judges in making such a judgment? Basically, they would have to make a judgment about what was too big a tax because it obstructed the action of the bank, and what was okay because it did not obstruct it. But that, I think, is fundamentally a policy judgment, not a legal one. That is why it is so perplexing for the judges, so unfit for them. In ordinary common law cases, it is true judges sometimes had to make such judgments, but in those cases, judges were not employing the extraordinary power of judicial review, striking down laws or acts of representatives of the people in a democratic republic. There was general agreement, I think, in the early years of American government that such a power ought to be used rarely, if at all, only when necessary, where a law clearly or manifestly violated the Constitution. But when the question was fundamentally one of degree, how big a tax had to be before it was an abuse, there typically would be no clarity. To wade into that morass of often arbitrary line drawing would be imprudent for judges. So judges in the early or traditional era of American judicial review preferred to find an intelligible standard, which usually was a question of evaluating the constitutional status of different kinds of power. That is why Marshall thinks the line could be drawn more clearly by relying on a theory of taxation, namely that states could tax those objects over which they exercise sovereignty. But at the same time, perhaps aware of the controversial character of that theory, Marshall in the end opted to rely on the principle that the power to tax is the power to destroy, and on the idea that decisions about which taxes were destructive and which were not was not appropriate for judges to make. I think that Marshall's argument about the potential for questions of degree to force judges into making policy decisions rather than legal decisions has been borne out in U.S. history, precisely because legal theorists and judges came to reject that approach and to institute a new, essentially different form of judicial review that entrusted judges precisely with questions of degree. The rejection of Marshall's dictum in McCulloch that the power to tax is the power to destroy is explicit in the justice who is the progenitor of the modern approach to judicial review, Justice Oliver Wendell Holmes, Jr. Holmes argued in a dissent in Panhandle Oil Company versus Mississippi ex rel. Knox, in which the court struck down application of a state gasoline tax to federal instrumentalities such as the Coast Guard, argued this: "It seems to me that the state court was right in upholding the state tax. I should say plainly right, but for the effect of certain dicta of Chief Justice John Marshall, which culminated in, or rather were founded upon, his often quoted proposition that the power to tax is the power to destroy. In those days, it was not recognized, as it is today, that most of the distinctions of law are distinctions of degree. If the states had any power, it was assumed that they had all power, and that the necessary alternative was to deny it altogether. But this court, which has so often defeated the attempt to tax in certain ways, can defeat an attempt to discriminate or otherwise go too far without wholly abolishing the power to tax. The power to tax is not the power to destroy while this court sits." Holmes treats Marshall's opinion as the reflection of an earlier, naive, less sophisticated understanding of judicial power, one that simply failed to recognize that most legal distinctions are questions of degree. He is entirely comfortable with courts that sit to make these determinations of degree. As Holmes says, in the modern era, judges have no hesitation about deciding questions of degree. In fact, the most characteristic form of judicial review in the modern era is one that essentially depends on deciding just such questions. Using the term in a broad sense, not in the narrow sense associated with Justice Felix Frankfurter, I think the typical modern form of judicial review is some form of balancing. The judge begins by identifying some broad general principle in the Constitution: liberty in the Due Process Clause, equality in the Equal Protection Clause, free exercise of religion in the First Amendment, etc. Now, none of these are absolute, of course. They are effectively broad presumptions in favor of the principles: liberty, equality, freedom of religion. On the other side are the asserted state interests in limiting the presumption. It might be, for example, a state interest in the education of children in a case involving Amish refusal to send their children to high schools as required by Wisconsin's compulsory education law. The judge then has to evaluate A, how much the state law impinges on the presumptive constitutional principle, and B, the importance or weight of the countervailing state interest, and C, whether the state interest outweighs the presumption. Such a process is replete with judgments about degree. How much is the presumptive constitutional value impinged upon? Lots, a little, somewhere in between. How significant is the state interest? Compelling, important, not so much. In the end, the process actually parallels many of the judgments that one would expect or hope to be found in the legislative process. But contemporary legal theorists and judges have a pretty low opinion of legislators, at least when the issues involved are civil liberties and equality. It remains to be seen whether the new court will share their opinion about questions involving property rights. This modern process cannot, in my opinion, reasonably be described as interpretation of the Constitution. It is, more accurately, I think, specification of allegedly vague constitutional generalities or presumptions. It is effectively a new kind of power, a form of modern judicial legislation. And this is a point on which Justice Holmes and most contemporary legal theorists, I think, would have no hesitation in concurring. Judges, however, have to be a bit more circumspect about such politically charged assertions. But the word is out, which is why the judicial confirmation process looks the way it does. It's unfortunate, I think, that the American legal profession ultimately turned its back on Marshall's prudent understanding of the limits of judicial power, embodied in his dictum in McCulloch, that questions of degree are so unfit for the judicial department. Thank you. Thanks.
We'll stay up there. Greetings to everybody. Thank you, Gary, for the invitation to come out. It's not often one has an opportunity to celebrate the 200th anniversary of McCulloch versus Maryland. So, this is the title of my talk is "The Sound of the Third Hand Clapping," and I'm going to begin with my first topic, which is the third hand. One of the most interesting aspects of the attention paid to McCulloch over the years, these 200 years, is the degree to which the most relevant literature was written well before the case occurred. Surely the most widely read commentary on McCulloch has been Alexander Hamilton's opinion on the constitutionality of the bank, which was written roughly 25 years before Marshall himself wrote the opinion in that case. The second most widely read commentary is the opinion in McCulloch written by Thomas Jefferson, an opinion prepared, as Hamilton's was, at the request of the president as he was thinking about whether it was constitutional for him to sign the bill. These are the two hands clapping. I mean, Hamilton and Jefferson, and I'm going to sort of incorporate Marshall's opinion in my discussion of the Hamilton opinion. So there was a third hand, however, that was surprisingly not among the most widely read and discussed of these early commentaries. This is the opinion that on the proposed bank delineated by James Madison. Madison was at that time a representative from Virginia in the U.S. House of Representatives. The relative obscurity of Madison's opinion is surprising, in part because of his stature, both in general and his stature as a constitutionalist, somebody who knew a lot about the Constitution. One reason, I think, that Madison's position on the first bank has been more or less ignored derives from the tendency by scholars to assimilate his position to Thomas Jefferson's. Jefferson, as is widely known, took his stand mainly on the meaning of the term necessary in the necessary and proper clause. The Constitution, said Jefferson, allows only the means which are necessary, not the merely convenient, for effecting the enumerated powers. If such a latitude of construction be allowed to this phrase as to give any non-enumerated powers, it will go to every one of them, for there is not one which ingenuity may not torture into a convenience. It would swallow up, he said, all the delegated powers and reduce the whole to one power. Therefore it was that the Constitution restrained Congress to the necessary means, that is to say, to those means without which the grant of power would be nugatory. Hamilton and Marshall rejected Jefferson's reading of the clause. But Madison's case against the bank nowhere depended on the Jeffersonian claim that necessary means that without which nugatory, or absolutely necessary, as was sometimes paraphrased. So therefore, Madison's position is not the same at all, actually, as Jefferson's. Although the unless nugatory test is not part of Madison's approach, it is a major part of Hamilton's. In a very famous part of his opinion on the bank, he takes strong issue with Jefferson's construal of the word necessary. Necessary, Hamilton points out, often means no more than needful, requisite, incidental, useful, or conducive to. Chief Justice Marshall made a very similar argument, as did Hamilton on this point. So the sound of two hands clapping is this cacophony produced by the different assertions made about the meaning of necessary by these two sets of writers. Mitigating that cacophony, however, is the fact that each of the parties developed a test to demarcate the line between what is or should be allowed under the clause and what should not be. For Jefferson, the test was this unless nugatory standard. Hamilton insisted that no matter how much looser his reading of the necessary and proper clause was, it still did not justify a theory of unlimited implied powers, as both Madison and Jefferson had averred about it. As a counter to these accusations, Hamilton laid down his famous test for legitimate derivations of implied powers. Quotation from Hamilton. The only question must be whether the means to be employed has a natural relation to any of the acknowledged objects or lawful ends of the government. This test not only delineates the scope of implication of the clause, but it also sets its limitations. Chief Justice Marshall laid down a rule very similar to Hamilton's, but I won't quote it. It's too long. So now I come to my topic, the third hand clapping. Responding in advance, so to speak, Madison disengaged from the debate over the meaning of the word necessity or necessary. As the congressional reporter restated Madison's chief point in the debate in the House of Representatives, he here adverted to a distinction which he said had not been sufficiently kept in view between a power necessary and proper for the government or union and a power necessary and proper for executing the enumerated powers. Madison concluded from this distinction that he called attention to that no power not enumerated could be inferred from the general nature of government. Had the power of making treaties, for example, been omitted, however necessary it might have been, that defect could only have been lamented or supplied by an amendment to the Constitution. For Madison, the decisive question is not, as it was for Jefferson, how necessary, but rather necessary for what. In this, he was much closer to Hamilton and Marshall than to Jefferson. Nonetheless, Madison still differed greatly from his two opponents in the case. Madison's answer to the necessary for what question is clear: a power necessary for executing the enumerated powers. Hamilton gave quite a different answer to the necessary for what question: whether the implied mean to be employed has a natural relation to any of the acknowledged objects or lawful ends of the government. For Madison, it is a matter of implied powers to effectuate the express powers. For Hamilton, it is implied powers to effectuate acknowledged objects or lawful ends. But what are the acknowledged objects or lawful ends of the Constitution? How do these relate, in turn, to the necessary and proper clause? The constitutional text, I think, supports the Madisonian position as an accurate and true reading of the Constitution. The Hamilton-Marshall position poses the difficulty of specifying how a court or other constitutional interpreter can establish the, quote, acknowledged objects and lawful ends. The Hamilton-Marshall position requires that the interpreter somehow infer these objects and ends from the enumerated powers as the first step in constitutional interpretation of this clause. Then the interpreter must reason from the implied objects or ends to the implied powers themselves. These implied powers are powers beyond the enumerated powers that do or can serve as further means to the objects and ends that have been inferred from the enumerated powers themselves. Hamilton and Marshall, in effect, reason up from the explicit powers to inexplicit objects and ends, and then back down again to powers that are means, further means, to the inferred objects and ends. Madison had introduced this distinction between objects and powers in Federalist Number 41, where he introduced a set of papers aimed at explaining the powers granted to Congress under the proposed Constitution. Instead of an exhaustive power-by-power treatment of all the granted powers, he first sorted all the powers into classes of powers as these relate to a list of objects. He identified 6 such objects, examples of which are such things as security against foreign danger or maintenance of harmony and proper intercourse among the states. He goes on to enumerate those powers actually enumerated in the constitutional text that relate to or serve as means to the effectuation of those objects. So, for example, security against foreign danger is a necessary object of the general government, and among the means for achieving that object are a group of enumerated powers, which I'm not going to read to you, but you can consult Madison in Federalist 41. This discussion of the powers of the proposed new government shares a great deal with Hamilton's rule for generating implied powers. Implicit in the various Madisonian discussions of the necessary and proper clause is a distinction between the legislator or constitution maker and the post hoc constitutional interpreter. The relation between objects and powers varies according to which role is under discussion. The legislator or constitution maker begins with objects. The goals, the ends, or the states of affairs sought in the Constitution, and then the constitution maker infers the powers or the chief powers needed to achieve those objects. In the American Constitution, these inferred powers are then set down as expressly enumerated powers, that is, they become the enumerated powers. No legislator can anticipate, of course, all the powers needed to achieve the objects or even to effectuate the enumerated powers. Therefore, it is simply necessary that there be some implied powers to fill in all the gaps that necessarily exist. The 2 main ways in which implicit powers can be provided for correspond to the differences between the Hamilton, Marshall, and the Madison positions on the question of necessary for what. Hamilton, Marshall, in effect, say necessary to achieve the objects and ends of the Constitution as they wow. If you saw my text, you'd know why I can't read it. Thus, for them, if the Constitution had contained no express power to make treaties, for example, they would infer such a power as necessary to achieve the acknowledged objects of security against foreign powers. They could argue as follows, or their position amounts to an argument like this. The Constitution makers could have, to meet their procedure, would have drafted a necessary and proper clause in different language than they actually used. The language would be this. Article 1, Section 9, maybe somewhere down there. Well, actually, it wouldn't be 9. 8, the last appended item in Article 8. Congress shall have the power to make all laws which shall be necessary and proper for achieving the objects and ends of this Constitution. But they wrote no such thing. As Madison has it, the interpreter has no right to rewrite the text in this manner. The language and procedure in the Constitution is not compatible with this Hamiltonian rewriting of the necessary and proper clause. First, the language of the clause does not fit their procedure. The clause very explicitly validates implied powers to effectuate expressly granted powers, which rules out the direct appeal by the constitutional interpreter to objects and ends. The Constitution makers began with a notion of objects and ends, but did not expressly grant all powers that might contribute to those objects and ends. The absence of some powers from the explicit grant of powers may have been quite advertent rather than inadvertent. Perhaps, for example, they did not intend to authorize torture as a valid constitutional power, even though it could be considered a means to national security. Madison thus found the Hamilton-Marshall approach to be in disaccord with the overall character of the Constitution. As a constitution of enumerated powers, that being its overall character, if later constitutional actors are free to appeal directly to the objects and ends that presumably guided the Constitution makers in their making, then it makes no sense for the Constitution makers to have listed the powers of the government in an explicit list of the powers granted and to include the power to appeal directly to the objects and ends of the Constitution themselves. Therefore, I am maintaining Madison's interpretation of the clause, first of all, picks out the most relevant features of the thing, and at the same time captures the meaning of the Constitution in a clearer and truer way than Hamilton and Marshall. Thank you. Oop, I think this was a mistake.
Good afternoon. The decision in McCulloch versus Maryland was immediately controversial because of its result, upholding the law creating the second bank of the United States. But in Virginia, the strongest criticisms were not about the bank itself, but about the reasoning that the court used in reaching its unanimous decision. Chief Justice Marshall wrote to his colleague Joseph Story that the opinion on the bank case has brought into operation the whole anti-federal spirit of Virginia. That spirit took to the newspapers in two sets of essays, and the second, lengthier, more formidable, and more harshly critical, was by Hampton, who was Spencer Roane, the most prominent judge on the Virginia Court of Appeals and an important Republican leader in the state. Marshall thought that the essays were intended to excite ferment among the people and in the Virginia legislature, to harm the national judiciary and to impair the Constitution. And so he took the extraordinary step of responding anonymously in the papers. Our interest here is with the essays by a friend of the Constitution, in which Marshall offers clarification of and elaboration on his reasoning for the decision in McCulloch. Ultimately, this defense becomes a defense of the Constitution itself. Now, a major claim of Hampton was that the Supreme Court decided McCulloch versus Maryland wrongly because it misused the doctrine of incidental or implied powers. His proposition was that the limited grant to Congress of certain enumerated powers only carried with it such incidental or implied powers as were necessary and proper for their execution, and necessary was to be taken in a very strict sense, meaning only those things without which the power could not be executed, or only indispensable means. With some extensive review of literature and argument, Marshall takes Hampton's source and analyzes it to reach a conclusion that the only principle which can be laid down safely is that instruments are to be understood liberally or restrictively as may best promote the objects for which they were made. And to get to that, Marshall said, we need to take into account the nature of the instrument, the words that are employed, and the objects that are to be affected. That led Marshall in these essays to an expansion of the famous "it is a constitution we are expounding," by focusing not only on the fact that it can describe only the great objects that the Constitution and the government are to attempt to achieve, but also that it is a document created by the people for their prosperity, that it is intended to continue well into the unforeseen future, and especially that it creates a legislature of the people's representatives to choose specific methods for implementing its powers as appropriate. Now, these observations lead Marshall into what he calls a still more decisive objection to Hampton's application of a strict standard of necessity to the case in McCulloch. And that's what I want to especially focus on here, because in this, Marshall develops a distinction that may help us see the opinion in a different light, one that shows from Marshall's perspective that, in fact, it was not about incidental or implied powers. Marshall notes that Hampton has failed to understand the meaning of the term means that is used frequently in the opinion and its relationship to implied powers. Hampton says that the term means is one that has been manufactured, invented by the Supreme Court for its decision in McCulloch versus Maryland. But Marshall shows that this is in no sense the court's invention. It is a term that had been used heavily in Hamilton's document and elsewhere, and by counsel in the decision or in the case in McCulloch. Most of the time, the term means and the terms incidental or implied powers seem to be used interchangeably, and this distinction between them is rarely drawn. But here, Marshall draws a distinction which he says is critical for the decision in McCulloch versus Maryland. There is, he says, an important difference between the two. The difference is important because the standards for constitutional legitimacy are different in the two cases. With an incidental power, or implied power, Marshall writes, we are always to inquire whether it appertains to or follows the principle, for the power itself may be questioned. On the other hand, where it is established that a power is granted, the legislature may select any means to execute it. With a power, for example, to constitute tribunals inferior to the Supreme Court, to pass a law to punish people who falsify records before such tribunals would be to assert an additional power, an incidental one, and Congress might be called upon to prove that that power is properly implied. But an act actually creating the tribunals, in spelling out their jurisdiction and procedures, in acquiring the buildings and so on, is not asserting an additional power, but a means to executing the enumerated power. If Congress should decide to change the number of tribunals or their jurisdiction or their places, it may do so at will. These laws, Marshall writes, are means, and the Constitution creates no question respecting their necessity. Again, since the power to make rules of government for the government of land and naval forces is included in the Constitution, a law enacting articles of war, for example, is, Marshall says, the instrument or means by which Congress has chosen to execute it. With those means, the doctrine of incidence has nothing to do. Thus, tests which might be used to apply to the determination of the constitutionality of implied powers need not be applied to means. No court, he writes, has a right to inquire whether the punishments inflicted by the Articles of War are necessary or unnecessary. Now, in the bank case, the importance of the distinction becomes clear. The constitutionality of the bank does not require an implied power or an incidental power to create corporations. It requires only the judgment by Congress that this particular corporation is a tool that helps to execute at least one of the powers that is expressly included in the Constitution. And so it does not require demonstration that it is an additional power without which the other cannot be executed, or that it is necessary and proper to execute the enumerated power. Rather, it is a part of the enumerated power itself. As James Madison characterized this in criticism of the decision, quote, "The expediency and constitutionality of means for carrying into effect a specified power are convertible terms." At one point, Hampton observes that all the court needed to decide in McCulloch versus Maryland was whether the bank was necessary and proper within the meaning of the Constitution. But Marshall's response is that it need not even decide that. The court's ruling is that if the bank was created by Congress as a means to execute a given power, it is not required to be necessary and proper in the Constitution's meaning or necessary in any other meaning in order to be permitted by the Constitution. Now, through the remaining parts of Marshall's essays, a part on the necessary and proper clause and on the court's jurisdiction, this congressional right to choose means as it judges useful so long as they are not prohibited by the Constitution is shown to be essential to the ability of the government under the Constitution to be able to provide for the prosperity and happiness of the people as it is intended to do.
Thank you. I'd like to thank Gary for organizing all this and for inviting me, because I'm not a student of constitutional law, and I'm probably going to make that pretty obvious. But I wanted to look and contribute by looking at some of the sort of financial economic aspects of the issue as opposed to the strictly constitutional law questions. And I think when you do that, one of the first thing that sort of strikes you is that the real purpose of the bank, as Hamilton wrote when he did his report, and look in economic terms, was to create a national currency for the United States, supplement the limited supply of gold and silver. So what is very striking then is when Marshall lists the powers for which the bank may be the appropriate means, could be seen as a means, he doesn't include the power to coin money and regulate its value, in other words, to create a currency. The reason was, of course, that the whole notion of what money was sort of less clear then, or at least was in flux. It was understood to be simply a matter of minting coins out of gold and silver, had nothing to do with banknotes and so forth. So the result is that he has to rely on these other powers like levying taxes, borrowing money, and so forth, where the connection is much less clear to what the bank is actually able to do. And I think that may account for some of the controversy that arose, because to say that the bank was necessary to borrow money for the power of Congress to borrow money on the credit of the United States was a sense to say, well, the bank had to sort of create enough money there so that the Congress could, borrow it, which takes you rather far. So I think that is one item that comes to mind when you look at it from a sort of economics point of view. I mean, we take that power to create a paper currency for granted now, but that was not the case back then. The other big issue, as was just described, is this question of whether Congress had the right to charter a corporation in order to do something. And that may seem like a rather strange issue now, because chartering a corporation is a very common act. I mean, you can basically create a corporation relatively easily now. But back then, that was seen as a kind of special operation. It required a law rather than just a bureaucratic decision. And it carried a whiff of what we would now call crony capitalism. And after all, that was what was going on here in a certain sense. I mean, the government was giving the power to sort of control the currency to a private, profit-making corporation. And this certainly raises issues of delegation, as was discussed a little bit earlier. I mean, in this case, it's not Congress delegating its power to the executive branch, but actually to private citizens. This came up in a very tangential way, interestingly enough. One of Maryland's attorneys argued that if Congress has the power to create the bank, which of course he said it didn't, then Congress would have to decide where the branches should be. It couldn't delegate this responsibility for the branches, i.e. to put one in Maryland. And he says if this power belongs to Congress, it cannot be delegated to the directors of a bank any more than any other legislative power may be transferred to another body of citizens. We've already discussed here a lot on the taxation issue, so I won't go into that, although I think it is of interest that there was another way Marshall could have gone without having to get into very fine decisions about whether a certain taxation actually obstructed the purpose of the government. Again, the same Maryland attorney said, can the bank and its branches claim to be exempt from the ordinary and equal taxation of property as assessed in the states in which they are placed? In other words, suppose the state government just taxed all banks in Maryland. Would that be at the same rate? Wouldn't that have been a useful standard? Now, Marshall didn't have to do this because the Maryland law in question only applied to the Bank of the U.S. But it does raise at least another answer to the question that was raised earlier, is how could you sort of limit the power to tax so it doesn't become a power to destroy? And one possible way would be by insisting on sort of an equal rates of taxation. Today, of course, if you live in Maryland or in Virginia or any other state and you own treasury bonds, the interest on that treasury bond is taxed by the state. Now, technically, if the state could tax the interest at 100%, you would never buy the bond, and Congress's power to borrow money would be affected. But if it's taxed at the same rate as any other interest, there clearly isn't any sort of problem. Now, just wanted to say a few words more generally about where this fits in our history and economic financial development of the United States. McCulloch settled the issue of the constitutionality of the bank, but of course it couldn't guarantee the bank's future. And in the 1830s, as you probably know, President Jackson killed off the second bank of the U.S. He regarded it as a kind of oligarchic deviation from true Republican principles. The demise of the second bank was followed pretty soon by the financial panic of 1837, and there is some debate about what the cause of this was, but the conventional view was that in the absence of the Bank of the U.S., state banks tended to issue too many notes. They tended to overbanking, overissuance, and it made them very vulnerable as note holders tried to convert their notes back into gold and silver at the same time. So it's a rather strange feature of U.S. financial history in a way that the financial system was much more sophisticated in the first 3-4 decades of our history than it was in the succeeding 7 or 8, because it wasn't really until 1914 with the Federal Reserve System that we got back to anything like the kind of banking operation that the Bank of the U.S. had done. And this was primarily due to Alexander Hamilton, who really was very much aware of all the developments going on in the financial world, especially the Bank of England and the expansion of credit and so forth that brought about, and was able to deal in a very sophisticated way with managing the financial affairs of the country. And his successor on the Republican side, Albert Gallatin, also had this similar sophistication. But by the 1830s and 40s, that had really been lost in the Jacksonian era. Now, it's impossible to say whether a national bank on the model of the Bank of the U.S., had it continued in existence, would have made much difference. Would it have affected the financing of the Civil War, for instance? Would it have been able to avoid the very frequent banking panics that occurred in the second part of the 19th century and eventually led to the formation of the Federal Reserve System? Now, it's just worth noting, the Federal Reserve System, unlike the Bank of the U.S., is part of the federal government. This is something that Hamilton thought would not be a good idea, that you couldn't trust politicians with the ability to print money, basically. But there is, however, one important sense in which this view continues, which is, as we know, the Federal Reserve System, even though it's really part of the government, essentially, there's some technicalities there, nevertheless very jealously guards its independence from the executive and legislative branches. And we've seen a little bit of that play out here. So that's sort of, I have to say about this from the point of view not so much of the constitutional law, but some of the economic and financial issues that it raised. Thank you.
One of my favorite lines from William F. Buckley one time said, "The greatest anticlimax in the English language is for God, for country, and for Yale." I felt kind of the same way as Gary read through the esteemed scholars and then got to Adam White at the end. But thank you very much for inviting me here today. Thank you to Rebecca as well, and thanks to the friends who have joined us. When Gary and Rebecca invited me to contribute to this project, and think specifically in terms of Chief Justice Marshall and the statesmanship he exhibits in McCulloch versus Maryland, I enjoyed the challenge because it's a good question. Does McCulloch versus Maryland reflect judicial statesmanship? And before you answer that, you have to ask, well, what is judicial statesmanship? Especially as it's best understood in the context of our constitutional republic. We throw that term around pretty easily, judicial statesmanship. In fact, I noticed as we walked in the room, the title of Judge Kavanaugh, now Justice Kavanaugh's Burns Lecture from 2017, Walter Burns Lecture, was from the bench, The Constitutional Statesmanship of Chief Justice William Rehnquist. People mean different things by the term judicial statesman. I'll get back to that. But even in the context of Chief Justice Marshall, it's not clear what exactly we mean when we talk about judicial statesmanship. Kent Neumeyer wrote a wonderful paper around the time of his Marshall biography, extolling the statesmanship of Chief Justice Marshall, but he was referring to the personal qualities that were so famous with respect to Chief Justice Marshall. But what does it mean for McCulloch versus Maryland and the Chief Justice's opinion in that case to exhibit judicial statesmanship? And the point of my paper is ultimately that I think we see a very special and important, a very distinct and important kind of judicial statesmanship at work in the opinion of McCulloch versus Maryland. Now, perhaps the first to talk about judges and Supreme Court justices explicitly in terms of judicial statesmanship was Tocqueville, or he was among the first. In Democracy in America, he says specifically of, first he says of Supreme Court justices, he says they are entrusted with political power, and quote, "Their power is immense, but it is a power of opinion. They are omnipotent as long as the people consent to the law. They can do nothing when they scorn it." In the immediate line, the lines that then follow, he talks specifically about statesmanship. Talking more generally about federal judges, he says, and there's a quote but with some dots in the middle, "Federal judges must not only be good citizens, educated and upright men, but one must also find statesmen in them." He says, "They must know how to discern the spirit of their times, to confront the obstacles they can defeat, and to turn away from the current when the flood threatens to carry them away with the sovereignty of the Union and the obedience due its laws." And of course, his description of judges in that respect is so characteristic of the rest of Tocqueville's discussion of judges and lawyering throughout Democracy in America. With respect to judges exercising political power, but doing so passively, not thrusting themselves into the political fray. Now, after Tocqueville becomes a series of scholars reflecting on the nature of judicial statesmanship through the 20th century. And in my paper, I touch on a few of them. Felix Frankfurter loved to pepper his papers and speeches with reference to judicial statesmanship, and it's not clear at all what he meant. He says, the court's wisdom depends upon a judgment of practical matters and not a knowledge of the Constitution, or at least that's what the judicial statesmanship aspect, the statesman aspect of Supreme Court justices is. A judgment about practical matters and not upon the knowledge of the Constitution. Much more recently, just a few years ago, Professor Neil Siegel writes at length on the virtues of judicial statesmanship. But for him, judicial statesmanship is the work of a judge in promoting the social legitimacy of the court's work. He says they do this by advancing the best social values and also by sustaining social solidarity. Not a whole lot of talk of the framers in there, mostly a more modern version of the work of a judge as a politician and a selector and refiner of national values. I think closer to the mark was the work of Harry Clore in 1985 in a paper on judicial statesmanship, where he said that judges and justices become statesmen that judicial statesmanship reflects a judicial recourse to tradition, or as he said, regime considerations, or even constitution transcending norms, but rooted in history and not too often. That the more the courts would resort to these principles, the more it would risk its own legitimacy. But the courts, as expositors of these deeper transcendent themes in our constitutional republic, it calls to mind in some ways Ralph Lerner in his paper on the circuit riding justices as Republican schoolmasters. Now, in response to Clore and others, we saw Matthew Frank reject all of this. Matthew Frank wrote a paper of his own in which he said all this statesman talk is contrary to the basic notions of judging exhibited and exemplified in Federalist 78. The framers expected the president and senators to be statesmen. Judges are just there to say what the law is. But what's interesting is that Frank, even for his deep disagreements with Clore and the others over whether judicial statesmanship is a good thing, for all those disagreements, he had a fundamental agreement that judicial statesmanship occurs when judges go beyond, or they supplement the text of the Constitution with values not found necessarily in it, or that judicial statesmanship is adding to constitutional dialogue. There's another way to think about statesmanship, I think, and I think it's the better one, and I think it's the one that's reflected in McCulloch versus Maryland. And it's the kind of statesmanship that Harvey Mansfield wrote of in his book, Statesmanship and Party Government, on the statesmanship of Burke, or Burke's version of statesmanship juxtaposed with Bolingbroke. Burke's statesman, according to Mansfield, quote, must lack candor and use rhetoric. Must lack candor and in its place use rhetoric. He said, quote, it's not that the statesman is unprincipled or above principle. It's rather that his principle loses its refinement in the translation to public speech. The idea that in furtherance of principle, the statesman must sometime recalibrate his speech, leave certain things unsaid in furtherance of those principles. Or, as Burke himself says in Thoughts on the Cause of the Present Discontents, the focus of Mansfield's study, quote, the temper of the people amongst whom he presides ought therefore to be the first study of the statesman. And then, of course, to recalibrate his own rhetoric accordingly. And that, I think, is the statesmanship exemplified by Chief Justice Marshall in his opinion in McCulloch. And on this point, I really lean heavily, both in my paper and today, on the work of Professor Daniel Schwartz, the University of Wisconsin. He wrote a wonderful paper just a couple of years ago called Misreading McCulloch versus Maryland. And the focus of his study is on what Marshall leaves unsaid, not on what he says. He points out that as Marshall works rebutting argument after argument from the challengers of the bank, of course he adopts so many of the arguments that are set forth by the bank's proponents, either counsel in that case, Daniel Webster and William Wirt and William Pinckney, but also some of the arguments advanced by Hamilton in the earlier documents 2 decades earlier. But Marshall, in adopting some of these arguments, subtly sidesteps most of the most controversial arguments advanced by proponents of the bank. Whether it's rooting the bank directly in the Commerce Clause, whether it's taking an aggressive view of implied powers, whether it is arguing or respecting utmost judicial deference to Congress's judgments with respect to what is necessary or proper. On all of these points, Schwartz contends that Marshall takes the less controversial positions. And when, after all, Marshall, throughout his career, one might have expected him to adopt the most nationalist opinions. So why did Marshall adopt the less controversial positions? Well, it was because so much of the bank argument, so much of the bank argument was undertaken in the shadow of the larger debates over internal improvements and all the other sectional divides that were looming across the country in the early part of the 19th century. The more aggressive arguments raised by the Federalists and other nationalists would have been, if adopted by the Supreme Court, extremely explosive and perhaps would have undermined the court's own legitimacy, as the court would be seen as taking a side in the upcoming debates over internal improvements and the American system. And so Marshall leaves a lot unsaid, even in the context of the necessary and proper clause test that he offers in the opinion. He says, quote, "Let the end be legitimate, let it be within the scope of the Constitution, and let all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consist with the letter and spirit of the Constitution, they're constitutional." As someone pointed out, Marshall never really connects the dots in his own opinion, explaining how the bank meets that standard. Some would assume that Marshall didn't connect those dots because he couldn't connect those dots. But Schwartz suggests that no, Marshall didn't connect those dots because to connect those dots would point too directly to ramifications with respect to internal improvements and other questions of nationalism. And so in all of this we see Marshall, the statesman, leaving things unsaid so as to protect the legitimacy of the court and the ongoing project of nationalism. Just a couple closing thoughts really briefly. As I said at the outset, Matthew Frank, in his article on judicial statesmanship, sets it against the arguments laid out by Publius in Federalist 78. I don't think that's necessarily obvious, or that's necessarily clear. In discussing the standards for judicial review, Publius sets forth such a deferential standard in some places that statutes ought to be affirmed as constitutional so long as they can be affirmed by any fair construction of the statute, or that the court should only strike down statutes when there is an irreconcilable variance with the Constitution, right? Which implies the court has to decide what is a fair or unfair construction, what is a reconcilable or irreconcilable variance. And in those spaces, perhaps, even Publius left room for judicial statesmanship. But the question I would end with is whether it's possible for any justice other than a chief justice to be a judicial statesman. The chief justice, by law or by tradition, has a number of special powers in the court, whether it's the power to assign judicial opinions, majority opinions, which involves the power to assemble majorities and decide which cases call for a broader majority and which ones the court can take a more aggressive position with a 5-4 decision. And all of this, I think, is probably the most room for judicial statesmanship. And in those respects, maybe you see the Chief Justice more than anybody else in the court able to pursue the ambition that Madison spoke of in Federalist 51. For the Chief Justice more than any other justice is the one for whom the interests of the man are most closely connected to the constitutional rights of the place. Thank you.
It struck me that there were some disagreements here. And I guess we'll start with the first one that came up, which is the degree of discretion. You think, Chris, your argument was basically Marshall would like to remove most of the discretion away from judges, and Michael's argument is that Marshall's opinion and that of Hamilton opened the system up to a great deal of discretion. So I wonder if you both would sort of tackle that, and then Bob's discussion about the difference between incidental and means. I wonder whether, again, this gets to the issue of just how much discretion Marshall is laying out in the opinion in a way that, those who are opposed to it could reasonably say, yeah, it might be a narrow decision on the bank, but underlying that is a lot more judicial discretion than we want to see.
Let me ask Michael a question. Okay, we're talking about the relationship between powers and objects, and you think that Madison focuses on the powers, whereas Hamilton and Marshall go directly to the objects, in a way, in effect, maybe bypassing the powers. And I think I'm asking the question: is your argument that the powers are in some ways more specific and more narrow, and the objects broader? So by skipping the powers and going to the objects, Hamilton and Marshall are not being as faithful to the document because they're able to read the objects much more broadly than the actual powers are read. Is that your argument?
No,
or?
not actually, but it does have connections to my argument. And one of the things that struck me as I was going through my paper here is we were under very strict orders to keep in around 10 minutes, or as Gary restated it.
I apologize.
As you restated it, 8 minutes, and I thought, oh, got a problem here. But I mean, it just struck me how much I had cut out. I mean, it was necessary for the event. But so I know a lot of the things I actually thought I was saying didn't seem to come out in the version that I presented. But let me touch this question of the relationship between powers and objects in Madison on the one hand and in the Hamilton Marshall approach on the other. My point isn't actually that the powers are completely omitted or absent from the Hamiltonian Marshallian approach to the necessary and proper clause. As I understand it, what they do is they act in a way the reverse of what constitution makers do. So constitution makers legitimately begin with objects or purposes or ends of the document that they're trying to construct. They think of those objects, and then they think of powers that serve those objects, that help achieve them. They recognize perhaps that they're going to miss some, but nonetheless, that's what they do. So what they put in the Constitution are not the objects, but the powers that they think service those objects. Hamilton and Marshall are going to work with the same materials, but in the opposite order. They're going to start with the powers that have been granted. They then try to infer what were the objects that produced the granting of those powers. And so, as in a way, Madison gives a good account of this in Federalist 41 when he tries to explain how the powers and the objects that are in the Constitution relate to each other. And what Madison does that's different from what they do is that he recognizes, yes, these powers were put in this Constitution to deal with some objects that the Constitution makers had in mind. However, they didn't put those objects in the Constitution. They put in the Constitution the powers. And then they said, we have power to infer further powers to effectuate the powers, not to effectuate the ultimate purposes and ends that we have in mind here. And therefore, Madison would say, yes, there is a power, a legitimate constitutional power to infer, to deduce, to imply further powers, but not further powers to the big ends that the Constitution might have had in mind. They didn't incorporate all of those powers that could have been incorporated. The example I gave was torture. So an object, legitimate object, national defense, but they didn't empower the government to employ torture for that. Now, maybe that was just inadvertent. Maybe they actually had in mind that would have been a great way to pursue national defense, but they left it out. And it's a question of whether, even if we grant that it is a way of pursuing national defense, we, if we're Hamilton or Marshall, have no way, no legitimate way other than our sense of what the founders might have liked or put in. We have no way of saying whether that was an advertent absence or an inadvertent absence. If inadvertent, Hamilton and so on would say, sure, you go and add it in, you know. If advertent, then you shouldn't do that. So that's my argument, that they both recognize that powers and objects are relevant, but they're relevant in different ways, according to them. And that for Madison, it's not legitimate to appeal directly to those objects that there were no powers put into the Constitution to deal with. So, or better put, to add in powers that were not there to actually deal with. So when Madison lists the relation between objects and powers in Federalist 41, he lists some of the big objects that he can infer from the list of powers given, and then he says something like this. As he's trying to explain the powers that are in the Constitution, he says, here are these objects, here are the powers that they incorporated, but they didn't incorporate any other powers, and what's in the Constitution are powers, not objects.
I don't think Marshall would disagree with you.
Well, he has a
I'm
different
less
test.
clear about Hamilton. I think Marshall would say it's just standard interpretation that you always interpret provisions in the Constitution in light of their objects. But I don't think he would claim to be appealing to the objects independently of the powers.
No, he's not appealing to them independently. Well, it depends.
But as
we don't have a
an
standard.
independent source of other powers.
That's exactly what he does, however.
Well, that's what Madison says he does, but I don't think he does.
No, that's what he says he does in his own formulation of his own test.
Bob?
That the object be legitimate.
Bob?
Well, just on that point, yeah. But where he's talking about let the object be legitimate and within the scope of the Constitution and so on, he's talking about means. He's not talking about implied powers. So in that case, it needs to be directly related to an express power in the Constitution. We don't really get if Marshall is to be taken, his friend of the Constitution is to be taken at his word, we don't really get a discussion about what might be legitimately implied under the necessary and proper clause, because the discussion of the necessary and proper clause that we get is in the negative. It is that it is not a limit on the means that Congress may use to implement whatever power it may have. We can perhaps infer from that how it might apply in the other way around.
But maybe should intervene, but Pinckney and others explicitly say you have to actually look at, as well, the preamble actually matters, right? These are the great ends. And somehow the enumerated powers got to be interpreted in terms of those ends. You can't use the enumerated power just for any purpose. It has to be for those ends.
Well, I think the Madisonian answer to that would be, well, if that's what we can do, they should just add the preamble. We don't need the rest of the Constitution.
Yeah. No, but he said it was interpreting the powers in light of the ends or the objects, which doesn't mean you're dispensing with the powers or that you're bypassing them in some way. It's that I think you phrased it very well when you said that, you infer from the powers what those objects are. But yes. I think for Marshall especially, I don't think he would have talked in terms of deriving powers independently from the objects.
Well, what Marshall talks about is deriving powers from ends. And end is an object or purpose.
No. I was going to, essentially the same point. I don't think Marshall would have agreed with you that he was doing what you said. In other words, that he was coming up with additional powers just because the government was set up for the general welfare and so forth. Although I must say that, I think it begins to look like that's what he's doing. And in the case of the bank, it's in part because the enumerated powers that he has to rely on don't really get to the basis of what the bank was all about, which was creating a currency. So he talks about taxing power, he talks about borrowing, he talks about armies, he talks about regulating. These are the ones he lists first on the enumerated powers. And none of them really address what the bank is about, unfortunately.
Or what it becomes.
Well, no, what it was. When Hamilton makes his argument for the bank in his report on the bank, he says we need a national currency. And this is going to give it to us.
Yeah. So
Thank you. You made my case.
Yeah.
Well, except that he wouldn't have admitted it.
Well, he wouldn't admit it. I don't see that as a standard of.
I want to get Adam jump in here. So, if if I took your some of your argument, at least what I understand, you're basically saying Marshall was the opinion itself is extremely limited in what the constitutional argument is about the basis of the bank.
Right.
Then, of course, as Abe points out, the bank turns out to be far different in importance for that. So is this, and then I guess turn to Michael as well about this. I mean, the Republicans have this problem, right? Which is that they keep saying no to the bank, except that then they vote for it, and then they sign the legislation, and they say we need it, and then they wind up running around going, but we really don't like this power.
Yeah.
I mean, so how does Marshall square that circle in the case, in your opinion?
Well, but even in that, Marshall's opinion leaves some things that the Jeffersonians could sort of declare victory from, right? When he talks about the Constitution needing to be a flexible document so that, or the construction of the Constitution be generous so that the government can deal with contingencies, exigencies as they occur, right? He's speaking in the context of emergencies, right? Or the changing times may make the same measure more appropriate, more necessary at one time than at another, right? And so he leaves some space in there to justify the bank first and foremost as being appropriate at its time. And at the same time, I want to say, even in the text where the court says we're going to, in the text of the opinion where the court says we're going to, the necessary and proper clause isn't totally unbounded, right? Just some of the language, I was just circling it as we walked in, where Marshall warns, should Congress in the execution of its powers adopt measures which are prohibited by the Constitution, or should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the government? It would be the painful duty of this tribunal to strike it down. So even there, the court says that we're going to look beyond just nominally what the Congress says it's doing, or that the court might do that, and we might actually make judgment calls about, and here I disagree gently with what was said earlier, make judgment calls about degree, about whether what Congress says it's doing really reflects what in substance it is doing.
I know you want to jump in, but you got to wait till.
Sure, fair enough.
So we're running out of time, so I need to go to our friends in the audience, and the usual thing, please identify yourself and try to ask a question. Please. I wasn't pointing it at you necessarily, but if the shoe fits, go ahead. Right behind you.
Thank you. Michael Maybach with the James Wilson Institute. Excellent panel. When Marshall deals with the states' rights issues against Maryland here, one of the arguments he makes, which really surprised me, he said, the Constitution was voted on by the people and not by the states, and yet we had male voters electing delegates to the conventions, and the 13 states then voted. This really was a constitution of the 13 states. It wasn't a national plebiscite. How can he use that argument the way he did?
Because the convention has no authority itself. Madison is explicit about this in the Federalist Papers. All the convention did was propose something. The only authority it got was actually from the ratifying conventions.
No, I'm sorry, I meant the state convention. Yeah. 13 state conventions were not a
But Marshall's response would have been, those states, when they ratified the Constitution, gave authority to, created a document that created a national government, not just a league or in the way that the Articles of Confederation was. It had 3 different branches of government. It acted directly on the people when it taxed, for example, rather than going through a system of requisitions, so that the nature of the document that the states ratified was, in fact, a national document rather than a confederation.
And also, the states weren't acting as states when they ratified. It was a separate convention within the state, so it was not the government. Although, if the distinction is between the simple, sort of national plebiscite versus the states, I mean, then there's a third way, which I think Marshall actually pointed to, and I think Justice Thomas tries to make this argument in the case about from Arkansas limiting trying to limit the terms of congressmen. He tries to reinterpret or interpret Marshall more truly to what he thinks was going on. But anyway, so.
Could I just add one point?
Yeah, sure.
Which is there's a distinction, but it's often concealed, and I think intentionally by some, which is between two different meanings of what it would mean for the states to have ratified the Constitution. One is ratification by the state governments, such as the way, let's say, the U.S. ratifies a treaty. The other is by the people of the states, and that's what Madison was extremely careful to engineer as the way it would be ratified. So it's ratified by the sum total of the people of the United States, of those states that actually ratified, which was eventually all of them. And so at the end of the day, it's actually ratified by all the people of the United States. And so Madison would say, at bottom, the sovereignty belongs here to the people of the United States, not to the states.
But then the Virginia Resolution sort of backs slightly away from that, right? I mean, he actually.
No,
it's different than the Kentucky Resolution, I take it, but.
Oh, you're talking about, not the Virginia plan.
But Madison's version of the Virginia Resolution really slips the states back in as a pop.
Well, he uses actually a deceiving language, I think, I hate to say this about the saint James Madison, but in Federalist 39, when he's going through the different aspects of the Constitution with the question in mind, is this a federal or a national thing? I think he gives a deceptive reading of the Constitution, of the process, when he says that it is the states who ratify it, therefore it's in that regard federal, but actually that's not what he understands. He understands that it's national because of the popular ratification.
Let the record show that Michael Zucker just called James Madison a liar. But anyway, so it's now in perpetuating
no, a statesman.
history.
I think it was a statesman.
This is on.
But statesmen are liars.
Back here, please.
Thank you. Name's Derek Webb. I'm a lawyer at Sidley Austin here in town. A question for Michael Zucker, but others can weigh in as well.
Derek was my student, so he can refer to me in
exactly.
that casual way. Yeah.
So if we are implying powers from other powers and not from ends, I guess one question is sort of what the powers are that we begin the analysis from. Now, the most obvious answer might be the enumerated powers.
Yeah.
But the necessary and proper clause seems to expand beyond the enumerated powers. So the language of the necessary and proper clause is that Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Those are the enumerated powers. And all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So what do we think that second or third set of clauses mean within the necessary and proper clause?
Well, there are other places in the Constitution where powers are granted other than Article 1, Section 8. And I think he has in mind those other powers.
Yeah.
Another possibility is the law of nations, too. If you're going to take Curtis Wright and distinguish between domestic powers and foreign powers, there might be certain attributes of sovereignty that aren't listed in Article 1, Section 8 that would still be part of the national power.
And there you might, if you're doing that analysis, you might defer or consider the ends of government to a certain degree. I mean, it seems like James Wilson, for instance, might have thought along those lines.
You might. Yeah. Well, I think there are other powers.
There's some obvious things. For instance, you have to set up a Department of the Treasury and a Department of State, and those are presidential powers in a sense that then need legislation in order for them to work. So it's that I don't think is an indication that there were other powers for Congress or for the federal government as such, but merely to pass laws that would enable the president and the courts to do their business.
By the way, Michael, do you agree with Madison that if the treaty power had not been included in the Constitution, the national government would not have had the treaty power? You could only lament it, the absence?
Let me clarify my own position on this. It seems to me what one should do on this debate that we're having here is concede that Madison was right about what the Constitution actually says, but that he's quite contestable in thinking that that's a good solution. That is, it may be that the Constitution went astray on this issue by being written in that way. And so personally, if it matters, I would hesitate to defend in a full-blooded way a Constitution like that, a Constitution in which we have nothing to do but lament or pass an amendment. Of course, partly what's happened is we believe it's impossible to pass any kind of important amendment, so we think we'd really be stuck if we accepted Madison's standard there. But I don't think they thought it would be quite that impossible to pass an amendment. You have a sensible thing here. We've come to realize we need to make amendments sometimes. Madison himself believed that. And therefore, we should make an amendment, and we could easily get agreement in the country to that, I suspect.
I think the only reason the treaty power actually needed to be mentioned was you had to discuss how it would relate to the different branches of government. In the absence of the treaty power, I think it would have, per the law of nations, it clearly would have been a power of the national government. But the founders wisely realized they had to raise this question of the separation of powers and to figure out where the powers would lie. Right?
Yeah.
But it's a question of, it is a sort of substantive power because it's binding the United States to something.
Yeah.
It's sort of like the borrowing power. The real point of the borrowing power is to say that Congress can, in fact, obligate the country to pay back money in the future. It can pledge the credit of the country to something.
So can I, I'm going to steal the last question. Maybe on the economic front of the thing, isn't the underlying, Marshall must have understood because he had read the Hamilton papers when he was doing the biography of Washington, that the consequence of reaffirming the bank would be, establishing or re-establishing or re-promoting, opening the door for, an understanding of the U.S. as a commercial republic. So the game here isn't about, some narrow interpretation. It's really about regime principle that the Federalists in general wanted. And in a counter to that, just to go back to Adam's point, what's striking about this is 1819, all of a sudden not out of the blue, but really pretty much out of the blue, all of a sudden we're relitigating, the founding. The anti-Federalist argument is resurrected. So the case itself strikes me, and the opinion strikes me as arriving at a time when Marshall was really trying, in some way, to so much more fundamental issues that he's putting through the door than just simply whether or not this fits within the Constitution, a charter, or a bank, or whatever.
Well, I think there's the passage in the opinion where he describes the country in this really big, he said between this, whatever, that river is in Maine and New Orleans and the Mississippi and the East Coast, we're going to be moving armies, we're going to be, transferring revenues from one part to the other, they're going to be marching back, armies will be marching back and forth and so forth and so on. That's a very un-Jeffersonian view of what the country was supposed to be, and that was certainly part of it. And
even Maine to Georgia is a pretty long trip back then.
Yeah, but it's the sort of contradiction of the Jefferson in the first place, is that why did the country get so big? Because he decided that he had the power to buy all this territory, and he just had to essentially have a kind of Lockean notion of prerogative to say, yeah, I'm going to do it, and if the people don't like it, they'll punish me. But
even with that Louisiana Purchase, we don't think of Maine to Georgia as particularly big these days, but for that time, it was really big. Yeah. And again, the bank served some really serious purposes in moving money around.
Yeah, but it's this question of necessity, I suppose, in one sense. It was a way of doing it, but it wasn't a particularly necessary way, and it really was doing something else. It was creating a currency. I mean, the real question in a way is, or one of the questions that's raised in my mind was, did the original notion of the Constitution have the sense of a federal government that would be responsible for what we call the economy? I mean, was it going to promote the general welfare in an economic sense of, was it responsible for prosperity or not? And that, I think, wasn't clear back then. I mean, the notion that the government somehow, managed the economy as a whole, as opposed to just, enforce the law and let people get about their business.
Wasn't this part of the reaction against the Articles of Confederation's weakness in this area?
Yeah, but
I was just going to say, in all of this, and also in some of his other great opinions like Gibbons versus Ogden, you see Marshall giving very clear no's to the states. No, you cannot do this.
Yeah.
Whereas the yes that he gives the national governor is much more nebulous. So he's at least shutting down that part of the debate and then allowing the full ramifications of the rest of the debate to be litigated in politics.
I guess I would argue that he's opening he's trying to find a way for the Madisons and the Gallatins of the world to sort of slip into what he thinks is the right constitutional order. Now, whether they didn't take that, but
they didn't accept it.
Yeah. So again, there's a reception afterwards, and we can continue the conversation. But please join me in thanking our panelists.
Well,